Dr. Dixit Mehta. You would be asking him to start with also.
From the honorable bench, may we please start with the proceedings?
Please.
Much obliged.
And all the best to all of you.
Council seeks permission to proceed.
Yes.
Much rather.
Here for the appearing for.
Council for permission.
Yes.
Council seeks permission to address the bench as a lordship.
Please do so, sir. Yes, please start.
May it please this honorable court, having restated that this court has jurisdiction under Article 32 of the Constitution. If a lordship is satisfied with this summary, the council seeks permission to proceed with the statement of facts.
You may proceed whether we are satisfied or not. We'll let you know later.
Except for Lordship, the Republic of Elko, a high-income nation, has a long-standing tension with its neighbor Texas over the mineral-rich state of Ajuha. Although the 2001 referendum declared Ajuha as a part of Elko, Texas continued to dispute the outcome, citing low voter turnout and military interference. In July 2024, Texas launched an armed intrusion into Ajuha, leading to civilian casualties during Elko retaliatory strike. My lords, amid global scrutiny, journalist Ms. Datta posted on social media platform advocating peace and a renewed right to self-determination. As Corporation Limited, a foreign intermediary, refused to remove the post after filing no violation of its terms of condition. Lordship, due to this, ALCO invoked Cybersecurity Act of 2024 and arrested the platform grievance officer and banned S Corporation for 5 months. This writ petition challenges the constitutional validity of this act, ALCO's obligation under ICCPR, and the legality of states' punitive action. With the kind permission of this honorable court, I now proceed to present on issue 1 and issue 2, and my co-counsel will present issue 3 and issue 4.
What is issue 1?
Issue 1 is whether a foreign entity can initiate a writ petition to challenge the constitutional validity of a law based in ALCO.
Yes.
Lord, before
How do we substantiate your commitments? What do you want to say? Whether you can or cannot?
yes, Sir, Lordship, we can.
Substantiate your submissions.
Lordship, before starting with the issue 1, the council seeks permission to just go with some preliminary submissions before this regarding the constitutional protection for the foreign entities. Your Lordship, the Constitution expressly confers the rights under Article 14 and 21 to all persons, thereby including foreign national and jurisdiction entities like corporations. These rights are not limited to the citizens alone. Lordship, can you turn to page number 31 of the compendium? Lordship, in Menka Gandhi case, law affecting personal liberty under Article 21 also have to satisfy tests under 19 and 14. Lordship, to simplify this, this honorable court has clarified that Articles 14, 19, and 21 form an inseparable trinity, and any law impacting personal life must be fair, just, and reasonable. Therefore, any measure affecting foreign entities operating in ALCO must withstand the constitutional scrutiny. Furthermore, Section 83 of the Civil Procedure Code recognizes the right of alien friends to sue in Indian Balkan courts as their private citizens, unless they are enemy nations without permission. The writ proceedings to extraordinary are an extension of civil jurisdiction when fundamental rights are at stake. In Hong Kong and Shanghai Banking Corporation versus Union of India, the Calcutta High Court reaffirmed that foreign corporations may invoke Article 226, where rights extend to persons Similarly, global jurisprudence in this principle, Zavidas versus Davis, the US Supreme Court held that due process right apply to all persons, including aliens. Likewise, in Lockwood versus Vedanta, the UK Court appeal upheld the foreign claimants' right to sue. My lords, S Corporation is incorporated in Delaware, operates in Elko with over 20 million followers all over the globe, and it provides a critical platform for digital discourse and civic participation. The nature of its operation and the manner in which its actions were taken of notice and hearing compare the invocation of writ jurisdiction under Article 32. If the lordship is satisfied with the preliminary submissions, the council seeks permission to address issue 1. So what is it you said that there was no hearing given? Lordship explained that. Yes, Lordship. Lordship from the detailed facts, it is clearly visible. On 29th, the company rejected the claim for removing the post. On 2nd, the S grievance officer was arrested and a 5-month ban was imposed. Lordship, there is no time, there is no preliminary hearing and post hearing also in this case. In Mehta Gandhi case, it was very much special. It was related to some passport case. The accused in this case was fleeing from this nation. If she was aware about her given the notice, she would have fled from the nation. So in this case, we had a preliminary hearing is not relevant. Post hearing should be allowed. And also in this case, neither the pre-hearing is allowed. And as far as the CSA is concerned, it doesn't allow for any tribunals and any hearing, post hearing also. And these facts are absent about the the criminal procedure also, whether the arrest was made properly or not. Nothing shall I reveal? No. President. It is respectfully submitted that there exists no textual bar under Article 32 to prevent a foreign entity seeking judicial review for violation of rights under Article 14 and 21. These rights extend to all persons and cannot be contained merely on the basis of national origin, especially where procedural due process and equality before the law are alleged to be breached. Lordship, the arrest of S. Grievance Officer on August 2, 2024 and a 5-month ban on the platform were imposed under Article 36 of the CSA, which prescribes penalty for failure to remove content as per LEA orders. However, statute contains no provision for a platform-wide blackout or custodial detention of grievance officers. Lordship, these actions were taken as established earlier without notice, without opportunity of hearing, and without recourse to an independent tribunal review. In AK Kriya, Lordship, can you turn to page number 38 of the compendium? Try not to be repetitive, sir. So you have a limited time, right? Lordship, it precisely thought about the rule of law. Constitution, the rule of law prevails over the entire field of administration. Every organ of the state is regulated by the rule of law. In a warfare state, it is inevitable that the jurisdiction of the administrative body is increasing at a rapid rate. The concept of rule of law would lose its vitality if the instrumentalities of the state are not charged with the duty of serving their function in a fair and just manner. Lordship, it gives the principle of natural justice, basically. Lordship, coming to the next point, that is in AP Ryupa, this honorable court had that arbitrariness is antithesis to equality. Here the state selected targeting of the intermediary S corporation while sparing the original speaker Ms. Datta, whose post was duly assessed under the platform's terms of service and found it to be non-violative. Such selective enforcements reflect arbitrary state conduct. Lordship, kindly turn to the page number 5 of the detailed facts, the proposition. Lordship, is also very good. Lordship, the very first line of the Article 28. 1 minute. Just a minute, sir. Yes. Legal practices.
The act. Yes.
No individual or legal entity. From interpretation, the very first sign of CSA 2024 says there is no discrimination between an entity or an individual. Mrs. Datta is untouched, while as corporation is punished. Then we move to the law to the selective silencing. This is not justice, it is a vendetta with vigilance. It is look like color level legislation. It was this legislation came in July 2024 and it was enacted very without proper legislation. It was enacted by the legislature. And the lordship, due to this, it is look like that it is a color level legislation. Lordship, we are also concerned about our employee. And Article 21, as interpreted in Tharak Singh case, it is not limited to mere animal existence, but includes the right to livelihood, privacy, free movement, carrying lawful business, arresting a grievance officer who has no personal capability, and disabling a lawful business without a lawful authority plainly violates Article 21 of the Constitution. It is humbly submitted that such action, just digital expression, undermines platform autonomy and bypasses the fair process. Even in the Minka Gandhi case, procedural law, the three tests of the was established for the procedural law, that is legality, fairness, and non-arbitrariness. Lordship it fails to in this test. If the Lordship is satisfied with issue one, the Council seeks permission to address issue
Which
two.
time is given for each issue? How much time is given for each issue? 10 minutes. You finished with your 10 minutes of the first issue, isn't it? You're moving on to the next issue?
Yes, sir.
Um,
Lordship, the second issue is whether a social media entity with commercial motives may maintain a representative reputation. My lords, it's well established that the profit motive of a corporation does not defeat its right to seek judicial redress where public law obligations are concerned. In Devpala consultancy, this honorable court held that corporate entities may initiate PILs in case involving wider community interest. Similarly, in Bennett Coleman, Z Telefilms, Janta Dal versus H.S. Chaudhary, this honorable court reaffirmed that entities performing essential public functions like facilitating public discourse, disseminating informations are entitled to constitutional protection and standing. Lordship, as corporation, by curtailing pending content, hosting a grievance mechanism, and enforcing takedown requests as per the law, assumes a quasi public character. This platform is act as a modern day agora, a technological state just like the traditional media, and thus must be afforded a constitutional deference. Lordship, we have to take some example here. If the same post was printed in a newspaper, did the state did the same action what it did with the social media platform? We are just an intermediary. We are not the speeches of the Mrs. Datta.
why do you think the state acts differently in relation to the print and the electronic media?
Lordship,
what are your submissions in relation to that aspect? As to the difference in relation there?
Lordship, the foreign entities doesn't have Article 19, but we have Article 21, the right to trade. And we are acting as an intermediary here. The speech and expression was of Mrs. Datta. And here we just acting as a platform. And it is a normal platform based on the algorithms and the endorsement of the post gets to the public. And your lordship, this function, the S corporation is a quasi public character.
You gave an example of the newsprint. See, newsprint is subject to other laws as well because it is produced locally. So as far as social media is concerned, it has more liberal thresholds of international publishing. So what the honorable bench asked was that how would that be applicable to the case law that you have cited? Newsprint example may not necessarily apply.
Yes. Lordship, currently the digital age is growing and social media platform was coming 2017 only. And as far as the laws are concerned, laws are developing. This MOOT problem is related to just the perimeter of the constitution. It does not extend to other laws. So saying anything without the facts is not admissible. And Lordship, as far as the current things are concerned, Digital Protection Act is implemented in 2023, which is similar to the Santa Clara principles. And Lordship, it is also submission from the side of ESCOM person is that its terms of service is based on the Santa Clara principles. The Lordship can turn to the page number 55 of the compendium. No, Lordship, mistake on my side. Page number 44. Lordship with me?
Please, page below the bottom.
Yeah. Yes. What do you want to say,
We,
Vishnu?
Lordship. We encourage the principals to urge companies to improve reporting mechanism following regarding these criteria: legitimacy, accessibility, predictability, equitable, transparency, human rights respecting, and source of continuous learning. Lordship, the law is developing, and we think that just like traditional media, digital social media platforms should be looked from that perspective. It is better in many terms. Although there are issues like fake news, misinformation, which are very much necessary to be taken care of. Even the hate speeches, due to which counter violence is public order is even S corporation also understands this and it also inculcates such thing in its terms of service.
You may confine yourself to the issue that you're referring to. Maybe the other aspects that you're referring to will be taken up by your learned brother. Yes. So don't traverse your issue. You finished, sir? You have anything more to add?
Yes, sir. Article 36 of the CSA also provides only for the fines and imprisonments for refusal to comply with the state law request. It does not authorize arrest without charges nor blanket bans. It was already established. This conduct with utmost respect is manifestly ultra virus, violating the principles as laid down in A.K. Gopalan case that executive action must strictly conform to the legislative authority. Lordship, in S.P. Gupta and Bandhua Mukti Morcha case, this Honorable Court held that where public wrong is committed against a determinable class, representative action is not only maintainable but necessary. Here, the 20 million users of X have been silenced through a blanket ban without recourse or remedy. What about the digital representation of those people? The Article 21 applies to them also. Even some are sharing their information on the social media platform, accessing it, some may be running their businesses. And also, this is a very major concern. This country is hitting their economy and the personal liberty of their persons also. Milords, international framework has already clearly established, just like Santa Clara principles permitting content removal only upon a valid government or judicial directive. This Honorable Court in Shreya Singhal case expressly held that intermediaries cannot be compelled to remove content without such lawful direction.
We are requesting you once again, sir, to confine yourself to the issue. The issue number 2 is whether the social media entity incorporated for engaging in commercial activities can file a petition for representative action. As regards the aspect of violation of the ICCPR or the CSA not being in conformance with the rules of natural justice or otherwise, are domains of your other learned brother or co-speaker who will be speaking. So, if you have finished on the issue numbers 1 and 2 in relation to the aspects of institution of the petition and that there can be representative action, unless my learned brothers have something to ask. Anything to ask?
You don't left his own comments for it.
Yes, Lord. Winding up on this way. Lordship, as far as Lordship, can you turn to the page number 61 of the compendium? Lordship, Bandhu Mukti Morcha case was related to the PIL. And in this case, representatives was allowed because it is a parents petition case. And Lordship, here, as established earlier, we are representing not only us, the S Corporation for the ban, its grievance officer for its arrest, and the wide range of public. And lordship, as established earlier, this all thing comes under the parents' prediction role. And lordship, as a conclusion, with utmost humility, the arrest of S corporation officers and the platform blackout were unlawful, arbitrary, and disproportionate. They violate Article 4921 and breach the CSS own provisions and suppress political digital speech without legal justification. As a quasi-public entity, S corporation possesses full legal standard to maintain this representative action under Article 32. Therefore, this petition must be admitted and constitutional regards must be restored. If the lordship is satisfied with the issue 2, the council reads its submission and allow the pro council to begin with issue 3 immediately.
So, let's program pictures. All right, let's showcase your next speaker.
For the honor representing from the distance.
The council seeks permission to approve it. Please, much request. You're on issue number C and D, right? The third and fourth issues.
Yes. The council seeks permission to address the bench collectively and to the lordships.
Yes. This is one set or there are separate sets? Only one. Remember in future, sir, whenever you address a bench, whenever you address as a bench and you can see the number of judges, you must have that many copies.
I sincerely apologize, my lord.
Yes.
Because
See, if after all a judgment is delivered by the entire bench, it's not by one single person. So how do the others get the benefit of what you're saying?
If this act could be forgiven, I shall be.
It has to be forgiven for the lack of time.
Yes.
Anyway, continue. What are you now stressing on?
I'm stressing on issue number 3, which is whether ALGO has breached its declaration under ICCPR by imposing a 5-month ban on S for its operation in ALGO. The first issue which is being raised that it is an unlawful derogation of ICCPR Article 19. My lords, the bench may refer to Article 4 of ICCPR, which deals with the derogation, and thereafter refer to Article 19, which deals with freedom of speech and expression. Shall I continue, Mama?
Yes. What is the relevant provision?
Article 19 and Article 4.
Article 19 and Article 4 of the ICCPR. What does it say?
Article 4 prescribes that if a state has to derogate from any article of the ICCPR, it must inform the United Nations and other member states and make certain communication. But in this case, since the state of Algo has not made any formal derogation, therefore Article 19 applies to the state of Algo. Article 19 deals with the freedom of speech and expression.
Yes.
According to Article 19 of ICCPR, it guarantees the right to hold opinion without interference and right to impart information and ideas through any media, subject only to the restrictions that are provided by law, serve a legitimate aim such as national security, public order, protecting rights and reputations of the other, public order, morality, and public health, and the measures which are necessary and proportionate to achieving that aim. The statutory framework and ultra-vires act by the state under the Cyber Security Act (CSA) penalizes, including imprisonment up to 3 years or fine or both, and they may be imposed only after conviction of compliance with a valid takedown order. In this case, no valid takedown order was made by the state to S corporation. The Act does not authorize blanket suspension of platforms, and by imposing a 5-month ban without legal basis, the state acted beyond its mandate. This action violated the requirements under ICCPR General Comment 34, marked by flag number 2. That states that laws restricting expression must be accessible, foreseeable, as well as be precise. My lordship, in Anuradha Bhasin versus Union of India 2020, marked by flag number 3, and Shreya Singhal versus Union of India 2015, marked by flag number 4, this honorable court emphasized that indefinite broad restrictions that suppress legitimate speech are incompatible with constitutional safeguards and international standards. Here, instead of addressing a single controversial post, the state silenced the whole platform users, impeding emergency alerts, journalistic functions, and civic engagement. Government failed to use less restrictive means and less intrusive alternatives such as URL specific blocking, users account suspension. There is no judicial supervised injunction or administrative takedowns was never pursued. Therefore, the state measures failed the necessary and proportionality test given under Article 19.3. My lordships, this act also violates ICCPR Article 9 and 14. The ICCPR Article 9 as well as Article 26 prohibits arbitrary arrest, mandates timely communication of the arrest grounds, legal counsel access, and prompt judicial review. The Article 14 as well as Article 26 guarantees equality before law and equal protection of law and due process. General Comment 35 expand arbitrariness to include actions that are legally excessive, unpredictable, or procedurally unjust. These standards are ignored also in Article 20 and 14 of ELCO's Constitution, which is perimetrial with the Constitution of India. In Megha Gandhi versus Union of India, as well as A.K. Kraipa case, this honorable court held that any deprivation of liberty must be on the ground of just, fair, and reasonable, and it established the principles of due process of law. However, in CSA, there is no provision for post-decisional hearing. If we leave even the pre-decisional hearing,
We would request you, sir, not to repeat things which your first speaker has already adverted to. He may have traversed into your issues, but nevertheless, those aspects stand already covered. He referred to Megha Gandhi, he referred to Prayapak, and he referred to the absence of any regulatory mechanism. You said all that.
very rigorous. Actually, I am trying to create a synergy that international ICCPR as well as constitutional provisions are synonymous to each other, and therefore the state has not only violated ICCPR but at the same time has violated the constitutional mandates also. But I shall keep that in. Discriminatory enforcement breaching ICCPR Article 26 as well as Article 14 of the Constitution. Disparity in treatment while S Corporation Limited was banned and its officer arrested. Ms. Datta, the journalist, the originator of the post behind the impugned post faced legal section. This discrepancy lacks intelligible differentia as well as a national nexus to public order or national security. This court, similarly in Navtej Singh Johar versus Union of India, as well as Ajay Hasia versus Khalid Mujib, held that arbitrary application of laws, even if facially neutral, constitute unconstitutional discrimination. The chilling effect on penalizing the intermediary who did not honor the content suggests a retaliatory action designed to intimidate platform and not to uphold law. Your Lordship, there is also denial of procedural fairness and violation of order of pardon, which is part of principle of natural justice. ICCPR Article 14.1 and 9.2, supported by General Comment 32, mandate prior notice, full disclosure of grounds, legal representation, and access to an impartial tribunal. But the state has been unable to inform us that on what grounds the grievance officer was arrested. What was his mistake?
Is there, 1 minute, sir, sorry to interrupt. Is there any provision under the CSA Act under which there could have been any action taken against the individual who had posted it?
Yes,
Which is that provision?
under Article 28, the state must have filled which states
Whereas, yes, what is it?
that no individual, page number 5 of the
Yes.
MOOT proposition,
Yes.
no individual or legal entity is allowed to publish or share content. Therefore, it covers individuals also.
Okay.
If even if they would have wanted to rope in the grievance officer, they should have roped in the originator first.
Okay.
Similarly, in Rich versus Balmer in UK and A.K. Kraipa, it established that even administrative decisions must follow principles of natural justice. There is also disproportionality and lack of least restrictive means. The proportionality test as established in K.S. Puttaswamy versus Union of India, marked by flag number 8, that an act must serve a legitimate aim, be rationally connected to that aim, and be necessary and least intrusive, as well as balance the harm caused against public interest. In this case, while national security might have been a valid objective, the 5 month blackout of a platform used by 20 million users over a single journalist post was not rationally connected to the stated aims. Necessary, given alternatives such as URL between suspension was not used. Therefore, we would also like to ask that the state also breached ICCPR Article 2, Subclause 3, which is the denial of effective remedy. If I will draw the attention of the page to CSA 2024, Article 36. Article 36 states that a person convicted under this section will face imprisonment for a term not exceeding 3 years and a 5,000 fine or both. The Supreme Court may also impose a restriction order. The power to impose restriction order has been put for this court. Then how could they ban all the items? Even a single account or user blockage needs the permission of this court, and that too upon condition. The S corporation fails to understand that where this magical figure of 5 months had come from, because the ban could have been for 5 days or 50 days or 50 years. Therefore, the state action is arbitrary and it is violating ICCPR as well as the domestic constitution of the alcohol. Now, if my lordship permits, I would like to proceed to issue 4. Any questions? Any questions from issue 1? Please proceed. The CSA was enacted on July 23rd, 2024 with the stated objective of regulating content posted on social media and offering of social media services in ELCO. Two provisions of CSA are particularly relevant, which are Article 28 and Article 36. Article 28, if we apply various doctrine, then this same court has held in case of rare single that Section 66A IT Act is cast so widely on it that any opinion on any subject would be covered by it. And if it is to withstand the test of constitutionality, the chilling effect on free speech would be total. If we go on the wordings of the Article 28, it uses words such as potential impact on sovereignty, pose a risk to electoral democracy, which a reasonable person might interpret direct or indirect encouragement or inducement, or acts that would endanger the electoral democracy. The petitioner fails to understand that what would constitute indirect encouragement or indirect inducement. And what is the ground for giving this ground as electoral democracy? It is not covered under Article 19 of ICCPR. Similarly, it is not covered under Article 19 of the Constitution of the LTO. Then how could a new ground be invented by the state to put a restriction on freedom of speech and expression?
Do you have any questions on reasonableness? You cited reasonableness in the ground. Do you have anything on reasonableness?
Yes, my lordship. If my lordship would refer to flag 8, which is KS Kutta versus Union of India, 2017, which I stated that there is test of proportionality, that how much action is actually required and necessary, that action must be proportionate to the problem at hand. Excessive action cannot be taken by state.
Can you explain what that excessive exercise? Excessive says the excessiveness in terms of planning stuff. I'm not able to hear. We are citing about reasonableness, right? Saying that probably it's unreasonable. But my question is, can you explain what is this excessiveness?
Excessive. My lord, what the excessiveness is that when a post is made, there was no notice issued to the originator, whereas the user could be easily identifiable by the government. Thereafter, the previous officer was arrested, but no notice was served to the S corporation to remove the post. Thereafter, a 5 month ban was imposed There is no legal sanctity to such a ban. The state simply cannot issue any ban. This action is excessive. Even CSE doesn't talk about the ban on the whole platform. So that would be my humble solution. Currently, we have you see that network dot com before the reason of the different project. We work on work on the having feelings that rotated for the relationship of the so however the operation was of this software and often on this. My humble submission is this that once you report certain thing through previous channel, then our content moderation team makes a decision on the basis of TUS. If the state was not convinced by our decision, then they could have served us some kind of notice. What they simply did that the state action are very informal and illegal because they are approaching Ms. Datta through informal sources. They are arresting the grievance officer. If I may make an assumption that even if that post violates the CSA 2024, what is the maximum penalty which would have been imposed on her? That is 3 years of imprisonment and 5,000 rupees of the fine. The 3 years of the imprisonment is of very light term. For that, that grievance officer could have been given a notice under 41A. He was arrested. Whereas the decision was taken by content moderation team. Then what was the fault of the grievance officer? Just because he is a citizen and he is working for our corporation, you cannot incarcerate him. That would be my question.
Where is the government with regard to the fact that they were approaching her with the of the other purpose?
My lordship, paragraph number 19, the fourth line. Paragraph number 20, the first line. Ms. Datta was also approached by Alco's LEA to remove her post from S. But how was she approached? That is not pronounced. You cannot approach a citizen. So, for example, somebody can stop my car and say to protect on some post. The whole proposition does not say the right. Otherwise, the state or any else should have properly submitted. Say the notice to the S corporation. Is the here the state is acting very informal. That is my purpose.
So presumption that
From this mood proposition, it is very much reasonable presumption that the state is acting like. We don't read that government now, what is the standard with result that just the result that is needed. There English national or other languages that they tell us as long as we know because we are made up with them to be to I would say that this would be the other part of my argument, which I'm being right. In Brandon versus Ohio, this case was quoted in the case of X Corporation, which is Union of India 2023. It said that prohibition of speech that directly incites imminent lawless action and procedural fairness is a universal requirement. Therefore, had the post directly incited violence or there had been any procedural fairness, then we could have placed that CSA 2024 is a legitimate law. Due to absence of these things, due to absence of component of incitement in which the task goes, I feel that CSA is unconstitutional. If my lordships could provide me with 2 minutes of that time, the question is just 2 minutes. Just 2 minutes. Much of that. I would like to draw the attention of this honorable court that in Shreya Singhal case marked by flag 4, this court distinguished between mere discussion, advocacy, and actual incitement of violence. What has been said is that advocacy of whatever type becomes incitement only when it is directed to inciting or producing imminent lawless action. Now I would like to draw the attention of the bench to the post made by Ms. Datta, which is given in page 7, the MOOT proposition, that the bloodshed in Punjab should stop right now. I don't think that any state should have a problem with this sentence. Then the next sentence proceeds that my heart goes out to everyone in Ajubha and the civilian population should be given their right to self-determination. This post has no reference to either the state of Animo or Tagus. It is a cry for humanitarian crisis and for help. If we move to the ICCPR Article 1, the Article 1 itself recognizes that the parties of this convention recognize the right to self-determination. If the state of ALCO is against the right of the self-determination, then why it signed or ratified this convention at the first place? Because it's the first article which says that. Thereafter, in Kunal Kamra versus Union of India, marked by flag number 13, the amended IT Rule 2023, empowering the government unit to determine what content is fake, false, or misleading, with adequate check and balance, creates a constitutional concern.
You have to stop.
May I proceed with the prayer?
Yes, you may proceed with the prayer, but you have to stop.
Much obliged, Your Honor. Wherefore, in light of the facts and circumstances of the stated above, the petitioner most respectfully prays that this honorable court may be pleased to issue a writ of succession to quench and set aside the Cyber Security Act 2024, issue a writ of mandamus, any other appropriate writ to immediately lift the ban imposed on petitioning platform, release the grievance officer, declare the impugned provisions of CSA that it violates the fundamental rights under the Constitution of ELCO as well as the International Convention, and declare that the pass such other or further orders as this honorable court may deem fit and proper in the facts and circumstances of the case. And for this act of kindness, the petitioner as a duty bound shall ever pay. And with this, I rest notice.
Thank you.
Thank you.
Respondents are done. You are finished with your case. You rested your case.
Wait, please, this honorable court. This is response.
Yes.
Permission to approve the dice.
Yes.
Much obliged. After this, the moment of may it please this honorable court, the council seeks permission to address the bench collectively as your lordships.
Yes, please.
Much obliged. Greetings to the honorable bench. This is counsel appearing on behalf of the respondent, that is state, in the matter of S Corporation Limited versus Republic of Alco. I am accompanied by my sister counsel and assisted by my researcher. Collectively, we form the body of counsel appearing on behalf of the state, that is Republic of Alco. If your lordships are well versed with the statement of facts, I shall contain the jurisdiction
That's
under
not
which.
very kind, sir. That sentence is not very kind. Just as a learning experience, if your lordships are well versed, please bear in mind.
The council
We don't take it very kindly. Continue.
The council please ignorance your ladyship.
Yes.
Your ladyship, if the council have the permission to move to the jurisdiction.
Yes, come to the issues.
Your ladyship, one of our contention is that the jurisdiction under which the petitioners have approached is not proper. Since the first two issues are being dealt by me, which are of the preliminary nature, relating to the maintainability locus standi as well as representative action, it is vehemently contended that the jurisdiction under which the petitioners have approached is improper. Representative action also includes PIL in this matter, writ petition as well as PIL. The petitioners have not filed any PIL under Order 38, Rule 12 of Supreme Court Rules 2013. That is one humble contention, my ladyship. Further, your ladyship, if I may have your permission, I would move to address the first issue.
Yes, please do so.
Much obliged, your ladyship. The first
Please address the bench, not just the ladyship.
Much obliged, your ladyship. Much obliged, lordship.
Yes.
Your lordships, the first issue reads as under whether foreign entity can file a writ petition to challenge the constitutional validity of a law based in ALCO. Your ladyship, your lordships, dura lex, sed lex. The law is harsh, but the law is law. One of the earliest submissions that I would like to make at the very outset is that the foreign entity is not a citizen. If I may have the permission of this honorable bench, I would like to take your lordships to the jurisprudence of citizenship that is based in Alco.
Yes.
Much obliged, your lordships. Your lordships, the first and foremost is the employment of the word citizen under Article 19. That itself speaks volumes when it is combined with Section 2F of Citizenship Act 1955, which expressly excludes companies and association of persons. And lastly, we come to 1973 case, Bennett Coleman case, which says that so long as the corporation is registered within the boundaries of the nation, it is considered citizen. Your Lordship, this is an entity which is not at all incorporated in Republic of Alco, it is incorporated in Republic of Delaware. Therefore, any contention with respect to Article 19 stands vitiated at the very outset. Now, if I may have the permission of Honorable Bench, I would like to address the first issue in its totality.
Please.
Much obliged, Your Lordships. Your Lordships, my argument for the first issue is that a foreign entity cannot file a writ petition challenging the constitutionality or the validity of a law based in Alco. My argument stands on two limbs. Firstly, that there is no violation of fundamental rights, and secondly, that the rule of locus standi needs to be applied strictly in this very case. To contend for my first line of submission, the first limb of submission, the case of AP State of Andhra Pradesh versus McDowell is highlighted on page number 9 of the memorandum of the respondents. A case copy for the permission of the bench, although it has already been highlighted in the memorandum of the respondents, a case copy for its proper perusal is also submitted. Now, in State of Andhra Pradesh versus McDowell, 1996 case, Your Ladyship, Your Lordships. In this case, the Honorable Supreme Court already held that there are only two grounds under which a legislation or a law can be challenged. Now, this was further expounded in 2016 judgment of Supreme Court Advocate on Record Association versus Union of India, penned by Chief Justice Khehar of that time. It is also submitted, that is mentioned on page number 9 of the memorial of respondent, and further a case copy to substantiate the same is also mentioned. The highlighted aspect of the judgment would give way to the four grounds under which a legislation or a law can be challenged. If I may be permitted to read, Your Lordships.
Yes.
Much obliged. Your Lordships, the first is it is beyond the competence of legislature. That is to say, doctrine of pith and substance and doctrine of color layer legislation. Your Lordships, it is pertinent to note that the petitioners have raised colorable legislation. Colorable legislation which says quanto aliquer prohibited ex directo, prohibited ex indirecto. What cannot be done directly cannot be done indirectly either. This is not at all about Article 246. The legislative competence cannot be questioned. So that argument stands vitiated. Further, this is a petition filed under Article 32. Now, the second ground, it violates
At any stage challenge legislative competence in enacting a law. They haven't.
Your Ladyship,
they didn't say that the legislature was not competent to enact an act.
Indeed, Your Ladyship, they raised the contention of doctrine of colorable legislation.
That's a different issue. When you make your submissions, bear in mind what you say. Continue.
Indeed, Your Ladyship. Your Lordship, the second ground upon which they have challenged is it violates Article 13 of the Constitution. Now, that is the only ground upon which the petitioners have approached this Honorable Court. It stands to submit that there is no violation. Now, I will be basing my contention on the very test that the petitioners have relied upon. The petitioners have relied upon the Milka Gandhi test, which says the golden triangle of Article 14, 19, and 21. Since the petitioners have admitted that Article 21 and the test of Article 21 can only be evoked if they qualify the test of 14 and 19. And since they do not have 19, and a submission that goes to say that 14 cannot be claimed to be violated solely on the basis of Article 14, it has to be joined with Article 19 for a claim of violation of Article 14 and 19. The case at point, the locus classicus, would be Power Measurement Limited versus State of Uttar Pradesh Power Corporation. Now, the highlighted aspects have been marked, and the last page clearly states of this judgment. It is also mentioned on the memorial of leadership, Your Lordships, on page number 10 of the respondents. Now, it says that the case copies also says that Article 14 cannot be claimed to be violated separately. It has to be in conjunction with Article 19. Now, this test
that the petitioners have relied upon stands vitiated. So any standing with respect to violation of Article 13 that does not, the court cannot, that does not submit, that is not submitted, Your Lordship.
With excessiveness. With excessiveness, reasonableness test, is excessive. What do you say on that?
Your Lordship, the test of reasonableness in this case, the excessiveness of punishment that has been done, it has to be kept in mind that this is a war-like situation in the Republic of Alco. Our neighboring country has occupied 3,000 square kilometers of land. It is also mentioned on third page of the MOOT proposition. In this situation, any remark with respect to self-determination of the dominion of Ajwa reflects poorly on electoral democracy of the nation, as well as it raises several national security concerns.
Just a minute, sir. As per the MOOT proposition at paragraph 17, Alco was able to regain control of the land occupied by takers.
Your Ladyship, I would move to page number, the third page number upon which
You said that the land was taken away, but the land was taken back.
Your Ladyship,
MOOT proposition at serial number 17, page 3, sir.
indeed, Your Ladyship. Pardon, Your Ladyship, Your Lordships. This is to say that they have taken over 3,000 square kilometers, but in this present case, Alco has taken back. However, the right to self-determination goes to say that there are several national security concerns. This raises the sovereignty, the question of sovereignty. That is why the excessive punishment. We cannot, as a sovereign nation, allow our citizens to talk badly or to talk against the national security or sovereignty of our own nation.
Can you elaborate are they talking badly?
Your Ladyship, the right
or affecting, or what they have said is affecting the sovereignty?
If I may have Your Ladyship and Your Lordship on Annexure D, the last page. Further, it is also submitted that this shall also be contended by my co-counsel. However, for the brevity of the proceedings, I would refer to the Annexure D, page number 7. Now, the second post, Funsuk J and Selina Khar. Now, these two people, these two personalities are dominant personalities of takers. Now, conjoining it with post of V. Datta says that right of self-determination can be derogatory to the dominion and sovereignty of Alco. Since these two personalities are leading personalities, political personalities, which have also joined hands with the journalist of Alco, it goes to say, and it is submitted, that this will raise several and severe security concerns. The excessive ban is not at all excessive in its nature. In fact, when a question of sovereignty is raised, several kinds of sanctions are also laid down. However, within the purview of the Act, we have only laid down only 5 months of imposed 5 months worth of ban. If I may relay it back to my issue at hand, Your Lordships.
Yes.
Much obliged. Now, it is vehemently contended that if they do not have any right, petitioners do not have any right under Airbus Engineering Company, highlighted also on page number 10 of the memorandum, as well as a case copy for perusal of this pen. If they do not have any right, they cannot claim any right. Nisi does nisi remedium. Now, as far as the locus standi is concerned, Your Ladyship and Your Lordships, it is submitted that it has been held bad in law that whenever a foreign entity has come before this court, citing and approaching this court within writ jurisdiction, it has held bad in law. And to substantiate that, I have quoted 2 cases on page number 10 itself. The third paragraph. Cosmos Tours and Travels Others versus Union of India and Power Management Limited versus UP Power Corporation Limited. A case copy of which is also submitted for perusal of this bench. Now, in both of these cases, the foreign entities that approached this honorable court had masked their Article 19 with Article 14. They claimed to have enforced their right under Article 14, but what they were doing was they were claiming their right under Article 19. Now, petitioners also allege that under Article 19, they have right to trade. It is submitted that Article 19(1)(g) is very clear that only citizens have the right to trade of the Constitution. if I may have your lordship's attention, the Constitution. Now,
Continue.
much obliged, your ladyship, your lordships. Now, the locus standi, as it stands, we also have a locus classicus, Fertilizer Corporation Kamnagar Union versus Union of India. Now, this goes to say that their representative character in this manner cannot be sustainable in this honorable court. Representative actions that shall be addressed in the second issue constitutes of only three mechanisms that I will be delving into in the next issue. Now, this says the case says that so long as they do not have any right, they cannot claim any right. Again, your ladyship, one humble submission is also one humble submission. Now, this goes to say that linking the first issue to the second, one case that is submitted for the perusal and also mentioned on the memorial itself on page number 11. Vinay Kumar versus State of UP. Now, in this case, the 3 pages have been highlighted. In this case, the Honorable Court held the opinion and held that so long as there is no injury to the third party, it cannot file for a representative action, which leads me to the second issue, which the dictum of which says whether a commercial entity, whether a foreign social media entity incorporated for commercial purposes, commercial activities, can initiate a petition for representative action. Now, for your lordship's convenience, I would like to state that there are only 2 viable mechanisms that can be raised at this junction for a representative action. First is class action, mentioned in Section 245 of Companies Act 2013. It is also submitted the flag aspect. And the second is PIL for representative action. Now, if I may have your lordship's attention, Section 240.
The CPC itself, you have provisions for representation.
Indeed, your ladyship, this is what I was coming as well. Now, they also have this third viable mechanism under CPC, but it is not for repetitions. Your ladyship has rightly observed that they also have it under CPC.
Even the trial courts are required to uphold and safeguard constitutional values and constitutional guidelines.
Indeed, your
and the
ladyship.
Constitution.
Indeed, your ladyship. And the petition may not approach the appropriate.
Whether it goes to a writ court or goes to a trial court.
Your ladyship, they should have availed the alternative remedy available, but they have not. That is also one of the contentions. Under CPC Order 1 Rule 8, they could have approached district court or any appropriate forum. But since they have approached this in under writ jurisdiction, none of the viable mechanisms have been utilized properly. So any kind of representative action on the part of the petitioner has not at all been invoked and neither can be held as tenable in the court of law. So the question whether the commercial entity can file a writ for representative action, the answer that the respondent submit in this particular case is no. Further, there are 2 further limbs upon which our case stands. First is the commercial entity cannot represent the interest of public, and this commercial entity in question is not at all incorporated in the Republic of Halko. It is incorporated in Delaware. There is this case that has been cited on page number 12. Harpal Singh Rana versus Union of India. Now, this honorable court has rejected petition with commercial interest at heart. That goes to say that any petition, any representative action on the part of the petitioner with a commercial interest at heart cannot stand in this honorable court. Further, this honorable court has been magnanimous enough to issue guidelines on PIL, the only viable representative action in this particular case. Now, this guideline says that any commercial matter, any PIL, on the second page of leadership, if you have it, any commercial matter, any matter with a commercial entity at heart, commercial motive at heart, it cannot be held as tenable in this honorable court. And since this is a social media entity, it only stands to benefit, it only stands to profit here when it comes to this honorable court. Further, lack of their exhaustion of alternative remedies also speaks volumes about their intent.
social media entity is not only for commercial interest, it also has a duty to spread awareness.
Indeed, Your Lordship.
The sense of reasonableness and excessiveness.
Your Lordship, if I may have 2 minutes of time to just address the query.
You may.
Much obliged, Your Lordship, Your Lordships. Your Lordships, social media entity do have, they have the right as well as the duty to spread awareness. However, in this case, the manner in which this has been utilized is very egregious to the nation of Algo. If we are separating our own dominion of Ajoha away from ourselves, if it chooses to secede, despite the referendum back in 2001, this calls for a grave action and error on the part of social media entity. Further, this is a commercial entity, and nowhere in law, nowhere, there is no strong presidential jurisprudence before this honorable court that has allowed a PIL from a foreign entity, that to a foreign commercial entity, to file a representative action before this honorable court. There is no precedence at all. Therefore, any representative action on the part of commercial entity before this honorable court cannot stand water, cannot stand ground before this honorable court. It cannot be tenable at all. It cannot be held as tenable at all. If your lordships and the honorable bench has any query before this council, the council submits the query of this honorable court. In absence of such, I would like to call upon my sister council to address the third and fourth issue, which is of the subject matter.
Any questions, sir?
One question. In the era of internet where freedom of speech is available, particularly on social media, only barriers at the state, maybe for the people guys.
Your lordships,
Even the conflicts in the past, you feel that maybe this wrong way or you might have to focus.
Your lordships, the new jurisprudence has been developed in this aspect by Honorable former Chief Justice Chandrachud in the form of test of double proportionality, in which Honorable Justice Chandrachud balances the right to information with the right to privacy. Now, these, Your Lordship, just to answer your query, further extension of just 1 minute. Now, these jurisprudence that is being developed, the locus classicus would be the electoral bond case of 2024, as well as the KS Vita Swami 9 judgment. Now, these cases speak volume about the new jurisprudence development with regards to digital sovereignty and digital right to
You may
information.
stop now.
Much obliged, Your Lordships. It was a pleasure arguing for this honorable bill. I really feel honored.
Your brother sister?
Your Lordships, the Council humbly seeks the permission to address Issue 4 before Issue 3, since any law challenged on constitutionality first must be tested against the touchstone of the Constitution of Alco before it can be challenged under any international format. Your Lordships, Constitution is the supreme law of the land, and even if it is enacted, any law enacted within the international conventions uh, any law challenged on the ground of constitutionality must meet the standards of the domestic legislation. If your lordships may permit, I would like.
Professor, we're arguing issue number D before C. That's what you're saying?
Yes, your lordship.
All right.
Not the blood, your lord. Your lordships, before I start with my arguments, I would like to submit to this court two contentions. First of all, your lordships, the court is requested to invoke the doctrine of presumption of constitutionality. Your lordships, he who asserts must prove. It is upon the petitioners to assert the unconstitutionality of Cybersecurity Act 2024. Unless rebutted, the presumption of constitutionality stands in the favor of respondents. Your lordships, quoting the judgment in the case of M. Nagaraj versus Union of India, 2006, your lordships may refer to page number 17 of the memorandum. The Supreme Court held that while examining the constitutionality of a statute, court should presume that the legislature understands and correctly appreciates the need of its people. Your lordships, the second contention that the respondent would like to assert is regarding the test of The test of golden triangle rule laid down in the judgment of Mehta Gandhi versus Union of India. Article 14, 19, and 21 are not mutually exclusive, and therefore the any law challenged on the grounds of either of these articles must fulfill the touchstone of all three of these. Your Lordships, the respondent would now like to advance the arguments with respect to Article 14, 19, and 21, clarifying how the provisions of CSA meet the touchstone of each of these articles. Your Lordships, under Article 19, one clause stated, the citizens of Alco have been granted freedom, right to freedom of speech and expression. However, Clause 2 of Article 19 restricts the same freedom under reasonable grounds. Your Lordships, any restriction on the freedom of
Clause 19 of what, madam?
the Constitution of Alco, Your Lordship.
Okay. Yes.
Your Lordships, any restriction imposed on the freedom of speech and expression must fulfill two criteria. Firstly, it must be in accordance with clauses 2 to 6 of Article 19, and secondly, it must be reasonable. Your Lordships, as far as the language of Article 28 and 33 of Cybersecurity Act is concerned, the language is in consonance with Article 19, Clause 2 of the Constitution of Ireland. Your Lordships, further referring to the test of proportionality as laid down in the judgment of Modern Dental College and case Puttaswamy, your Lordships, the test shall be advanced in four prongs. First of all, there must be a legitimate goal that the statute is trying to achieve. Secondly, the restriction imposed on the content, it must have a suitable and rational connection to the object that is being sought to fulfill. Thirdly, the action must be absolutely necessary. And fourthly, it must be balanced against the interest of the people whose rights are being restricted. Your Lordships, applying the test of proportionality to the cybersecurity. There exists a legitimate goal, Your Lordships. Article 33 reads out the language of Article 19, Clause 2 of the Constitution, and therefore serves the legitimate aim of upholding the sovereignty, security, and maintenance of friendly relations of the nation of Alcohol.
You need to relate your submissions to the CSA Act because we are dealing with the constitutionality of the CSA in relation to Article 28 and Article 36 that has been put forth at page 5.
Your
You
Lordships,
need to bring out the aspect that whether those terms and those provisions are constitutional.
indeed, Your Lordship, Article 19 is one of the touchstones that the respondents are contending. Further, so, as the arguments will be advanced, the constitutionality of CSA will be asserted against Article 14 and 21 in due time, Your Lordships. Your Lordships, kindly refer to page number 5 of the MOOT proposition itself, laying down the Article 28 and 36. Your Lordships, the language reads out you know also level to clarification since article number 33 was not included itself in the MOOT proposition. That has been added later in the clarifications. If your Lordships may permit me to read the article number 23.
Essentially, yes, ma'am.
Your Lordships, Article 33 reads, where the central government or any of its officers, specially authorized by it in its behalf, is satisfied that it is necessary or expedient so to do in the interest of sovereignty, integrity, defense, security, or public order. Your Lordships, the clause is directly from Article 19, Clause 2 of the Constitution of Ireland. Therefore, Your Lordships, the contention that the provisions of CSA serve a legitimate goal. They are in consonance with the Article 19, Clause 2 of the Constitution, and they are within the wires of the Constitution, Your Lordships. Your Lordships, as far as the necessity and the balancing state of the proportionality test is concerned.
Now, please respond to Article 28. What is this endangering of electoral democracy? What is meant by this electoral democracy? What is the ambit of this?
Indeed, Your Lordship.
Does it fall within the contours of constitutionality?
Your Lordships, electoral democracy is not the only ground that has been incorporated in
When you look at an enactment and when you consider whether or not it is constitutional or not, you're not going to read it in isolation, isn't it?
Indeed,
You have to read the entire enactment to see, and specifically when that particular article is under challenge. You need to tell us what you understand by electoral democracy and to what extent there is equality in this aspect.
Your Lordships, I shall be answering the question in three parts.
Yes.
First of all, Your Lordships, reading into the legislation is the act that is best left to the legislature because it is presumed by this honorable court and it has been asserted in the judgments of R.G. Bell versus Union of India and Swiss Railroad that the court must believe in the wisdom of the legislature. Your Lordships, secondly, the actual question of imposition of ban on the possession of eggs was not on the ground solely to the threat that was posed to the electoral democracy. Your Lordships, Article 33 leaves out several grounds that have been taken straight from Article 19 Clause 2 of the Constitution. Thirdly, Your Lordships, if this honorable court holds that the ground is insufficiently defined, the same can be supplemented by enactment of procedural rules and making an addition of a brief section in the legislature itself. Your Lordship.
So as of date, according to your good self itself, those procedural safeguards are inexistent.
Your Lordships,
That's your submission. They can be enacted, you say.
Your Lordships, again, Your Lordships, I will be answering in two parts. First of all, my contention was not with regards to the procedural safeguards. Secondly, Your Lordships, it was in regards to the definition of the term electoral democracy. As far as electoral democracy is concerned, that is not the only ground of imposing the ban. If it if it's the need of the situation that the definition needs to be added in the legislature itself, that can be easily the act can easily be amended to include another clause. Penalties that cannot be the sole ground of declaring the statute as unconstitutional, since it's a lengthy procedure to enact a legislature. And again, your lordships, the court must believe in the wisdom of the legislature because it is believed that the legislature knows the needs of its people.
That's that offers protection can be planned to effect to be solved on to that and then increase question.
Your
Simply the reason where we know we have several.
Your Lordship, as far as procedural safeguards are concerned, I shall be answering it in very detail under Article 21, but just to answer your question for your satisfaction, Your Lordships, procedural safeguards have been granted in this present situation as well. Your Lordships, the when audio auto pardon is in a situation when audio auto pardon is not explicitly mentioned in the language of a statute, it is implied in the proceedings. The same has been guaranteed by the central executive in the present situation that has prompted the petitioners to challenge the constitutionality of cybersecurity at your lordships. If your lordships may allow a minute, I shall be elaborating the answer in very detail to Article 21. Not the right, your lordships.
But you have not answered the query that the honorable bench asked in the first instance. And also with respect to the issue of implementation. The question is not only on constitutionality, also on the riveting, so that it meets that steps or not.
I believe your lordship is referring to the proportionality of the actions. Your lordship, referring to the case of Bennett Coleman versus Union of India, in which it was highlighted by the Supreme Court that the effect test should be followed by the test of comparative term. Your lordships, align the content to circulate on the social media pose much greater harm to the sovereignty and security of the nation than restricting the freedom of expression of people for on temporary basis, your lordships. Your lordship, again, your lordships, the provisions of CSA cannot be challenged on the ground that the actions are disproportionate, since it would depend upon case to case basis, your lordships. And in the present case, the proportionality criteria have been met.
How are they met?
Pardon, your
How is the proportionality criteria met, madam?
Your lordships, it was not just Ms. Dutt who posted in favor of right to self determination. Several social media users have been posting with regard to the content that would harm the sovereignty of the nation. Your lordships may refer to proposition for the preservation of the facts. We also may refer to page number 3 under para emails. Many social media users in Arab call to their government to conduct a free and fair referendum. Your Lordship, amongst the ongoing armed conflict, it was the need of the keeping in mind the urgency and the exigency of the situation, Your Lordships, a prompt action was needed on part of the government. Your Lordship, secondly, keeping in mind the urgency of the situation, when audio on part or principles of natural justice cannot be granted, given the imminence of the harm that the action in question poses, the same can be granted post decision. Same can be substituted by post decision hearing, which is in form of writ petition, Your Lordships. Your Lordship, to substantiate my point further, Article 69A of the IT Act 2000. Your Lordships, the only procedural safeguard granted by that is in form of writ petition under Article 226. Your Lordships, that was the only ground of upholding the article. And the petitioners are not debarred from bringing a writ petition against the action taken by the executive either, Your Lordships. They have been granted the right to challenge the constitutionality of CSA as well.
So the writ petition is maintainable through your submissions.
Your Lordships, that is
Coming out.
Your Lordship, that is up to the court to determine. However, they have been granted a chance to question the authority of the government to in what under what authority they are taking the action. However, they must have taken the suitable means to question the extent of the power of the executive. Your Lordships, I believe my co-counsel have already asserted that the petitioners have not utilized the adequate remedies that are available to them, and therefore their petition is not maintainable. If your Lordships may permit, I may relay back to Article number 21 and test the provisions of CSA against touchstone of Article 21.
Yes.
Your Lordships, in the case of Maneka Gandhi versus Union of India,
What is Article 21?
the right to life and personal liberty, Your Lordship.
What does it say?
No person shall be deprived of right to life and personal liberty except according to procedure established by law.
Alright. Yes, so now come back to the act.
Your Lordship, referring to the judgment made in Cooper versus Wandsworth Board of Laws. Your Lordship may refer to page number 18 of the memorandum. The same has been quoted by the respondent. Justice of common law will supply the commission of the legislature. However, Your Lordship, there has been no commission on part of the legislature. Your Lordship, Section 69 of the IT Act is supplemented by IT Rules 2000 to provide for a procedure of blocking the information with regard to Section 69. The rules provide, the rules grant supplementary rules and procedures as a direction to the executive, Your Lordships, and the same and provisions of CSA can be easily supplemented by provision of rules, and the same may not be the ground to declare the entire statute as unconstitutional. Your Lordships, further, moving on to Article number 14. One of the major conventions of the petitioner that the said sections of CSA are arbitrary and they do not follow the test of reasonable classification as laid down in the judgment of State of West Bengal versus Anwar Ali Sirkar. Your Lordships, the test of reasonable classification has two limbs. First of all, there must be an intelligible differential, and secondly, it must have a rational connection it must have a rational nexus with the object of that. Your Lordship, the contention of the petitioner is that there is no difference between the print media and media of internet as a medium of expression. Your Lordships, the petitioner in their submissions have contended that there has been no ban that has been imposed on the freedom of speech and expression that have been granted through print media. Your Lordships, referring to the judgment made in the case of K.R. Singhal versus Union of India, may refer to the judgment. Your Lordships, the bench in the present case clearly highlighted the existence of intelligible differentia between internet as a medium of expression and other forms of media, including the print media and broadcasting media. Internet as a medium has far wider reach and brands and is easily accessible by public at large. Your Lordship, several social media users have been posting against the sovereignty of the nation. Threat to sovereignty cannot be ignored, Your Lordship. Internet poses much greater threat as opposed to print media. And Your Lordship, this further contends that the state does not try to control the narrative because they have not imposed any ban on print media. Your Lordship, several articles have been posted in the newspapers as well. Your Lordship, the state does not try to control the narrative. They have not imposed any ban on any of the articles, or they have not taken any action in furtherance of the same. Your Lordships may refer to them proposition for the nature.
That was one of the contentions raised by the other side, that the person, the proponent of the document, is not held up, whereas it is the intermediary against whom action has been taken. So is it not arbitrary?
Coming to arbitrariness, Your Lordships. Arbitrariness,
You have just 2 minutes, ma'am, and you'll try to finish it.
indeed, Your Lordships. Your Lordship, first of all, apprehension of arbitrariness in the executive action cannot be account to challenge the constitutionality. This has been asserted in the case of Special Court Bill versus Unknown. Your Lordships, further, arbitrariness is challenged from the second ground, that is vagueness. This has been contended by the petitioners. Your Lordship, Article 92 provides that the restriction must be such that a reasonable man considers it to be absolutely necessary. The same test of reasonable man has been incorporated in Clause 3 of Article 28 and has been sufficiently defined. Reasonable man test, as elaborated in Clause 3, states that any action, any content supporting the person who is stating any action who is inciting to offense against the national security would be considered as incitement of offense. Your Lordships may refer to Clause 3 of 28 for further clarification. I believe I've elaborated about arbitrariness. If your Lordships may permit, may I please have Mr.
Yes.
Your Lordship, equity relates to the international covenant on civil and political rights. Your Lordship, this to contention under the same. The restrictions imposed on the freedom of speech and expression are within Clause 3 of Article 19 of International Covenant. Your Lordships, there is a three-pronged test. Firstly, the restriction must be prescribed by law. Your Lordships, Article 69A clearly, Article 69A of the IT Act clearly grants the government the power to impose a ban on the apps. Your Lordships may refer to the notification of Ministry of Electronics and Information Technology. Under Article 69A, a ban was imposed on 59 apps in the interest of sovereignty and national security of the citizens. Secondly, Your Lordships, the second leg of the test, that the action must be in pursuance of a legitimate need. Your Lordships, I have asserted the same, that it's in the interest of sovereignty, public security, maintenance of friendly relations. And thirdly, Your Lordships, if Your Lordships may allow 2 minutes to something, merciful. Your Lordships, the necessity is to be determined by the existence of a pressing social need. Your Lordships, further, the rapid plan of action elaborated by United Nations General Assembly. Your Lordships may refer to the NGO. Your Lordships, there are 6 parameters to attest whether the speech in question violates the Article 19 or not. Your Lordships, firstly, the social and the political context of the speech. The content in question was in favor of self-determination against the sovereignty of the nation. The status of the speaker, Your Lordships, Miss Duff, Mr. Funsuk, and Miss Selina Khan, they're prominent political speakers, Your Lordships. They have vast reach, they have vast influence over the citizens. Your Lordships, the third leg, the intent to incite the audience against a target group. Your Lordships, the comment of Mr. Funsuk, it clearly states that he appreciates the people for standing up for people of Ejima. Your Lordships, there is clear incitement of offense. Your Lordship is also ticks against the it also ticks against the criteria that is laid down in reasonable man test of clause 3 of Article 28, that there is a support granted to the person who is inciting the offense. Fourthly, Your Lordship,
Just a moment to intervene. Now you were referred to the post of Mr. Fonso. The post of Mr. Fonso is referred in paragraph 16 of the MOOT proposition. But whereas the aspect of taking them down in the legal proceedings in paragraph 19 at page 3, there is mention only in relation to the aspect that MS Datta's post was not taken down despite having been asked. So there's nothing to show that Openshuk's post was called upon to be taken down. So where is the action in relation there? It was not, as per this proposition at least, the facts don't show that Funsuk's post was called to be taken down.
Your Lordships, the petitioners have challenged the constitutionality of the act. Constitutionality must not be tested against a single action. It depends upon case to case basis. If Your Lordship may permit 2 minutes.
Thank you.
May I read out the prayer, Your Lordship, if you could
Yeah.
grant me a minute?
Okay.
Nothing else. Your Lordships, in the interest of the Your Lordships, thank you. In the light of the capital matrix, issues raised, arguments advanced, and the authority cited. This humble respondent humbly requests the court to firstly hold and declare that a foreign entity cannot file a writ petition and dismiss the petition in default. Secondly, your lordships to hold that a social media entity incorporated for commercial activities cannot bring a suit for representative action. Thirdly, your lordships to uphold the ban imposed on S and declare it intra vires the powers of Article 19 Clause 3 of International Covenant on Civil and Political Rights. And fourthly, your lordships to uphold the constitutionality of Section 28, 33, and 36 of Cybersecurity Act, and or pass any other order as the court may deem fit in the interest of justice, equity, and good conscience. And for that, we shall be duly bound, your lordships. It was a pleasure arguing before this court, your lordships.
Right. Oh, see, sleep sitting here, we make our analysis here, we go to we come this is very clear because the mics you want us to be clear. Yes, because this is not we can't discuss it in their presence. And you want us to come back after that. Well, you do that. You do the honors. Okay. There was time for rebuttal in yours. All right, you take them. You should have told us. Say what you want to, sir. But make it brief and 2 minutes means 2 minutes.
Your Lordship, actually, we have reserved 3 minutes from our question.
Two, sir.
Okay. Well, first, I would like to make this submission. If your lordship could refer to flag which was submitted in my complaint here, the state prays that Article 14, 19, and 21 comes together. So it means that if my 14 and 21 is violated, but my 19 is not violated, I cannot approach this court. It is as if that state is responsible to make an amendment to the constitution without restricting to Article 368 because I am an incorporated company and my 14 and 21 are violated. But if my 19 is not violated, how which provision stops me from approaching this court? Thereafter, I think that my learned counsel is ignoring the fact that right to livelihood is affected. When our clearance officer is arrested, then it produces a chilling effect on our employees. And their right to livelihood is at stake, thereby our Article 21 is affected. I think my learned friend is also unaware about the case Ash Corporation versus Union of India 2023, where previously Twitter, now X, filed a writ petition under 226 for the violation of same articles.
Where was it filed?
Madras Tribunal,
Karnataka.
Karnataka.
Yes. You should be factually correct, sir.
I apologize.
Yeah.
And thereafter, we challenge this doctrine of colorable legislation because the originator was not arrested. Because the originator is a citizen and she has her freedom of speech and expression intact, thereby they are targeting the intermediary, our platform, to gag her rights over speech and expression. And how is the situation warlike? There was no formal proclamation or national emergency imposed. Then how could a state claim that the situation is warlike in the country? If we could take the example of some countries, there might be some areas which might be under occupation of their neighbors, but it doesn't mean that they could impose restrictions on the Article 19 of their own citizens. And the respondent fails to understand what purpose does this ban serve to the state when the originator is free, other platforms are free.
All right. You must stop. That's a partial repetition of what you've said.
Much obliged.
Thank you.
Permission to sir.
Sir, rebuttal.
Your leadership it is well within the bounds of
That the organizers will tell us whether you have a provision for sir rebuttal. Sir rebuttal can be granted by a court, but it's within your competition terms.
Any further rebuttals to that?
Maybe your leadership I'll be addressing the questions raised by the Christians. Permission
To that extent. To that extent, sir.
indeed your leadership.
Yes.
May I approach that?
Yes.
Much obliged, your leadership, your lordships. Your lordships, the money Manka Gandhi test that the petitioners themselves raised. They say that 21 can only be evoked so long as they claim violation under Article 14 and 19 in conjunction. Now, the case that I submitted, power measurement case, versus state UP board, your leadership, and your lordships on your bench for your perusal, it submits that so long as Article 19 and 14 are not at all claimed to be violated, Article 20 and 21 cannot be claimed to be violated at all. The same case as the petitioners allege that right to livelihood under Article 21. The dictum of the case that is submitted before this honorable court in the power management case, power measurement case, the second last line of the second last page says that Article 21 cannot include right to livelihood because it is already included under Article 19(1)(g) for corporations. It is the very dictum, it is the verbatim of the judgment. Therefore, any questions with respect to right to livelihood of any corporation, a corporation is incorporated because it wants to do business, it wants to trade. Therefore, that petition, the petitioner's question is not tenable before the court of law. Lastly, in Anuradha busing case, the ban of internet in Kashmir was upheld. That is all. To answer all the questions raised by the petitioner. Much obliged, your leadership, your lordships. It was an honor and pleasure arguing before this honorable bench.